need to stop or you need to leave. He's told that multiple times. He's told that by Officer Robertson, by Captain Doherty. Mr. Nelson argued that he was never told to leave, that it was always contingent. However, he was told multiple times by multiple people that if you do not stop recording, you need to leave the property. At that point, after being told by the third person, Officer Boyce effectuates an arrest for second-degree trespass. Based on his testimony, based on his body cam, based on Mr. Nelson's video, he's present when he's been told to leave or stop recording. He's not witnessing leave. In fact, Mr. Boyce tries to engage him about leaving, and then Mr. Nelson wants to argue with him about what second-degree trespass means. At no point does Mr. Nelson ever take any initiative or ever give any indication that he's going to willingly leave on his own. Again, having his implied consent revoked due to the conduct that day for being in the health department recording without any express permission or without any authority to do so. The state would contend that Officer Boyce did, in fact, make a lawful arrest for second-degree trespass. After he made the arrest for second-degree trespass, the state would contend that Mr. Nelson, at that point, when Mr. Nelson winds up on the floor, based on the counters on the videos, there's probably a good 5 or 10 minutes where they're trying to get him up in a wheelchair and get him out of the health department and over to the magistrate's office. That's 10 or 15 minutes. Again, you can hear there's a scene being made while that's happening. Again, while this is still being live streamed on YouTube, mind the court. So Mr. Nelson is continuing to resist until he gets to the courthouse. So having answered those questions, arguably, the state would contend to the court that there's no First Amendment issue. He was in fact trespassed. Officer Boyce did observe him being trespassed, and he did trespass him himself. He was trespassed by 3 people with the authority to do so. And then after he was trespassed, he continued to resist by causing a struggle there in front of the pharmacy area of the health department. So based on those reasons, I'd ask the court to deny the motion. The state would contend there's no merit to the motion. Ask the court to deny the motion, but I'll respect the court's ruling.
What I'm going to do is I'm going to reserve to have a chance to look at these cases, and I'll let y'all know something this afternoon. Thank you.
Generally, these restrictions are viewpoint neutral and generally applicable because they don't limit a defendant's right to speak, and they're reasonable in terms of the purposes that those policies serve before. In the Hodge case, just draw the court's attention to some holdings on page 3, where it indicates that there's no First Amendment right to communication that guarantees the right to carry a cell phone in a government building, because cell phones can be used to photograph and or record closed or sensitive proceedings for unlawful purposes. Prohibitions of cell phones in the courts and public buildings is a common precaution. The inconvenience or discomfort to individuals based on security measures do not rise to the level of constitutional violations. I would submit to the court that that's what this policy is over the health department. It's not an unreasonable policy. Again, I believe when we had our first hearing on March 1st, a couple weeks ago, there was a policy indicated on the door. And again, realizing that Mr. Nelson is visually impaired and does not read the signs when he goes in, but the court took judicial notice of the sign on the door, and underneath that sign, it said something to the effect of no recording devices allowed without express permission. Just draw the court's attention, there's been no evidence submitted whatsoever that Mr. Nelson did have express permission to carry his devices into the health department and use them to record. And that's exactly what he did. He's admitted that he did that. His evidence that he put on shows that he did that. He told the court in the video that we watched today, the first video, you saw 2 video frames. The first one on top is the one that he said was from his GoPro that was recording before he entered the health department and continued to record. The one on the bottom was from the cell phone that live streamed the video on YouTube. So he went into the health department recording that encounter in violation of the policy. In violation of the policy that courts have reviewed and have stated that there is no constitutional violation. And again, without any evidence whatsoever to suggest that he had any express permission to do that in the health department. Draw the court's attention just briefly to some notes from a previous video that was showed the last time. I believe that Mr. Nelson showed a video from January 13th on March 1st, where he was interacting with Lieutenant Bowen with Guilford County Security. Lieutenant Bowen told him that it was okay to bring a cell phone to communicate or navigate, and then explained to him that he could not record in the lobby of the health department, but if he had an appointment with a healthcare provider, at that point he could record that if his healthcare provider consented to that recordation of that appointment with the doctor. So again, nothing to suggest that on February 4th, Mr. Nelson came into the health department with any express permission to record. Again, we know why he was there. He admitted to the court why he was there. He was there to record what was going on. And just briefly, before I move on to the trespass issue, addressing the reasonableness of the policy, I think it's worth pointing out to the court and the court considering before you make your deliberation on this, the reasonableness of the policy. Mr. Nelson contends that there is no expectation of privacy. There's no difference in expectation of privacy from someone walking from the commons area into the health department building. However, the state disagrees with his interpretation or his view on that. Again, Ms. Barbie told you that there are people that go in there to receive services who are children, who are juveniles. There are people that go in there to receive services that are victims of sexual assault. There are victims of crime in there to receive healthcare services. There are folks in there who are there for sensitive matters. And again, they do have an expectation of privacy once they walk through that door where it's posted that you cannot record in here. This is different recording in here from recording outside. There is an expectation of privacy that they have once they walk through that door, that they can go in there with some sort of degree of anonymity if that's what they're choosing to do. And again, that's what the policy is in place for. That's what Ms. Barbie articulated to the court. The policy is reasonable. There is no First Amendment issue here. So because there's no First Amendment issue, moving on to the trespass issue. The issue is whether or not his implied consent to be in that public building is revoked. Once he goes in there recording with his GoPro and with his live streaming camera. Draw the court's attention to just a couple of cases, State v. Nickens and State v. Hunt, specifically State v. Hunt. That was a case from Asheville. That was an incident where a law enforcement officer was working security for a restaurant in his off-duty capacity. In that capacity, he still maintained the power to arrest if he needed to. There was an incident where an individual came and approached the restaurant multiple times. He was told to leave. He continued to come back 3 or 4 times. And eventually he was trespassed. Now, he was trespassed on the sidewalk. Again, I understand the issues there with the sidewalk being public, but he was trespassed on the sidewalk, placed under arrest, and then engaged in a struggle with the law enforcement officers. He was ultimately charged and convicted of RDO, assault on a government official. In all candor to the court, the jury did acquit him of the second-degree trespass charge. However, the court did find in that case that the officer had PC to arrest him for trespass because he kept coming back after being told to leave, after he had come to the restaurant for making a scene. I recognize initially there was no belligerent scene, there was no disturbing scene. Mr. Nelson was not initially causing a disturbance when he was in the healthcare building on February 4th. However, it did escalate to that point the longer he decided to stay in there and engage with Mr. Robertson, Ms. Barbie, Captain Doherty, and Officer Boyd. Based on the case law the court has, one's implied consent to be in a public building is revoked. after the implied consent would be revoked in the cases that Mr. Nelson cited the Markopoulos case. In that case, the implied consent was revoked after that individual started a disturbance. In the cases that Your Honor has before you, then the State v. Hahn case doesn't really address the implied consent. It's more the PC2 arrest for the trespass. However, the State v. Nickens case, that individual was trespassed out of a DMV building. The DMV would be a public building after creating a scene, after they wouldn't give her her driver's license back because she wanted to wear a hat in the picture. DMV employee told her that she could not keep a hat on in the picture. So she began to get belligerent with them and eventually engaged in a struggle with some of the DMV security workers. Again, here, the reasons that Mr. Nelson's implied consent was revoked. Again, no evidence to suggest that he had any express permission to be in there recording on February 4th. After he's previously been to county buildings and previously been put on notice or told that he cannot record in these buildings, he goes in there, he's recording on 2 different devices. Miss Barbie testified to you that she watched it before she engaged with him that day. Officer Boyce told you that he brought up the YouTube live stream before he engaged with him that day. So they are aware that he is recording once they encounter him. Again, because he's previously been put on notice that he can't do that, the state argues that that's all we need at this point to revoke his implied consent. He's told you need to stop or you need to leave. He's told that multiple times. And the court also indicates that generally these restrictions are viewpoint neutral and generally applicable because they don't limit a defendant's right to speak, and they're reasonable in terms of the purposes that those policies serve before. Again, that's answered through the cases that reference that, mainly with the implied consent issue. And then the third question, if there's no First Amendment issue, if there's no trespasses, it's a lawful arrest effectuated by Officer Boyce. Briefly, on the First Amendment issue, I've handed Your Honor 2 cases. That is the Benzig case as well as Hodge v. County Board of Commissioners. These are federal cases. The Benzig comes out of the Western District of North Carolina. That's a June 2020 case. Just will draw the court's attention to pages 6 and 7. The important holdings by the court in that case is that it does note that there is no absolute First Amendment right to record public officials doing their duty. Specifically in the context of this case, it's talking about recording in government buildings. The court goes on to reason that courts have previously upheld restrictions concerning the use of cell phones in government buildings, where it cites the Hodge case. It cites that the courthouse's own policy indicating that grants him the ability to take his phone or cameras or devices that he has for the purposes of recording inside a public building, specifically on February 4th, 2020 at the health department. The second question. Go, Jeff.
So if a member of the staff or employees at the facility are violating policy, are you trained to make sure that they are following policy?
I don't know. It's their policy. I mean, I don't, as far as the staff, I'm not there to watch what they're doing.
And did you assist me with identifying that individual?
No, because you were being placed under arrest by that officer.
Yes, sir.
Okay. Let me draw your attention to the body camera video that you took on January 31st, 2020. You said you reviewed that this morning in the courtroom. Is that correct?
Yes, sir.
You also said you reviewed the body camera footage of February 4th that you took. Is that right?
Yes, sir.
Did you review any other notes or any other material in preparation for your testimony today?
No, sir.
Any other video?
No, sir.
Okay. Back to the 31st. How long was I there at the courthouse?
I cannot recall how long you were there.
Was it longer than 10 minutes?
Possibly.
Was it longer than 30 minutes?
Probably not.
And the body camera footage that was played in court was less than 10 minutes, correct?
Yes.
Why does the body camera footage not have the entire encounter?
Because it wasn't turned on until it was turned on.
And was that body camera issued by North State?
No, sir.
And was it a personal body camera?
Yes, sir.
Did North State Police have a body camera policy?
No.
Okay. Are you familiar with public records law in North Carolina General Statute 132?
Back to the relevance.
I'll sustain that.
No, sir.
The relevance is it's a public record he creates with his body camera, and there's laws dictating on how to preserve that for evidence.